appeal part heard in the matter of Solicitors Regulation Authority Limited and Soophia Khan and others.
Mr. Arnold.
Thank you, my Lord. My learned friend and I have just had a brief word, and there are a couple of points of housekeeping, really, that I want to address you on just for a moment or two. One, the only substantive one is a correction from something I've read overnight that I feel ought to make. Dealing with the easiest points first, yesterday I mentioned during the course of argument two decisions. I didn't give the court either copies of them or the full citation. But in case it would assist, I have copies today of the decision in Maitland-Hudson and SRA 2019 EWHC 67, which is, as I said I thought was true yesterday, that is where Mrs Justice Carr's judgment summarises what is said in Solanke as the appearance track. That's where I have that epithet from. I can hand that up if the court would find it of assistance. I also have copies of the decision that I mentioned in Discovery Land Company and Gyre House, 2019 EWHC 1633, Chancery decision of first instance of the late Mr Justice Henry Carr. I
think we'd like to take the copies.
I propose to say nothing further on them.
No, I mean, as to the first, you already aired the point. As to the second, it doesn't seem to arise in the context of this appeal.
I
but
agree.
It would still be helpful to have the copies.
Exactly. Well, I'm happy to I can hand those up now. Check I have 3 copies of each. I have copies for my learned friend as well.
I've got copies, sorry.
If that would happen. Indeed, my learned friend actually sent me the Discovery Land Corporation Company judgment.
Yes. Yes, that's it.
And the other point, which is marginally more substantive, but I think uncontroversial, is we have had arguments before the court, and indeed in writing, on the criteria in Ladd and Marshall on the admission of fresh evidence. And when looking for something else entirely this morning, I came across a reference in Aldridge to the decision in Ertelli and Squatiri. Now, that case
has been emphatically disapproved subsequently.
In Varmer and Atkinson, yes, my lord, but I think, as far as I read the decision, it's been disapproved on one point in the decision and not the other. This may explain why it sits somewhat under the radar as you look in the footnotes of the specialist text. In that case, as its substance concerned the necessary mental state for a finding of contempt of court, and in that respect it has been emphatically overturned in Varmer and Atkinson, as my Lord Justice Arnold says. It also is authority for the proposition that under the old RSC, given that cases of contempt of court involve liberty of the subject, it is not right to apply Ladd and Marshall strictly, but rather to consider the approach under the Criminal Appeal Act, whereby fresh evidence is admitted where justice so requires. And on that point, I cannot see anything subsequently which overrules it. Now, to a certain extent, it's water under the bridge, because as I, in fact, took the court to, in making my application for fresh evidence, Ladd and Marshall is no longer binding. Rather, the test is the overriding objective, to do justice according to the details of the overriding objective. And Ladd and Marshall is a convenient expression of the principles that the court should apply in balancing that with finality of litigation. But having cited Ladd and Marshall, and now come across this, I felt I needed to bring it to the court's attention.
And you've got a copy of that?
I have got copies of that as well, and again, my learned friend has a copy of this already. It probably only means that liberty of the subject is another factor to consider in the exercise of discretion, which I suspect we all thought anyway.
Yes, that's slightly ironic in the sense that you're trying to use it to ensure that someone goes to prison. But
well, my lord, in that case and on our application, it may therefore have no weight at all. I wouldn't argue against that. But as our case concerns subsequent evidence in any event, there's also already authority that Ladd and Marshall isn't the right place to look. The reason I mentioned it now is partly to correct the submissions I made on that application, and partly also because my learned friend is, I think, about to move an application as part of one of the other appeals for permission to rely on fresh evidence in the form of Dr. Rajpal's report. And in that case, in our skeleton, I think we have, in light of this, we've emphasised Lavin Marshall. Whether we've overemphasised it or not is a point for argument. But it didn't feel right to argue it without this being before the court.
Thank you very much.
My Lord, that's all I needed to say.
Mr. Bogle, I don't know whether, if there is anything you want to say about the Italian Squat Treaty, you can just wrap it up in your submissions as you go along.
Indeed. There is a couple of other authorities, my Lord, which have been mentioned. What have I done with them? Sorry, my Lord. Still getting that out. My Lord. Which have been mentioned yesterday. I'll deal with them as briefly as I can, without peroration. And they are, a moment, the case is in order. Invidious against Thorogood. You have Jaya House. There are two Jaya Houses. One, it's 1633, but you copy that now. Deutsche Bank and Sebastian, and Coates and Turner was mentioned.
Well, we were given Turner and Coates yesterday.
Yes. Subject to what your Lordship says, we have copies, I think, of all of those.
Let's take all of those, but what propositions do you seek to extract from them?
Well, that's Deutsche. Where are the other ones? That's Deutsche. I think your Lordship has Coates and Turner already.
Yes, I do.
That was Lord Justice Peter Jackson. A question of... You have those already, my Lord, do you?
We've had Turner and Coates already.
Deutsche Bank?
No, we have not had that. It has been mentioned, but we haven't yet received copies.
Sorry, we need another one. Mine's highlighted. Oh. This one is highlighted. Is it all right if I hand that up?
If Mr. Alquist has no objection, then I'm content.
No, Your Honours, I have no objection.
No.
Although, no, I have no objection. I assume that my learned friend will refer to any passages on which he intends to rely.
Indeed. That was the issue of deployment. Most of these are dealing with that, the two issues, one deployment, one adverse inferences. That was where Lord Justice Peter Jackson's, and the relevant paragraphs are 13 to 15, in which he cited...
Can I want to get clear where we're going. As I understood it, you were going to deal very briefly with any remaining points on the main appeal, and then you were going to open the company's appeal.
That's right.
Now, in terms of, well, take Deutsche Bank first of all. To what does that relate? The main appeal or the company's appeal?
The main appeal.
And for what proposition is it relied on?
Well, the proposition was that the issue of right to silence, some of the allegations could not be made without reference to the undeployed evidence. Parts of the proposed particulars would therefore infringe the defendant's right to silence, and the final form of the committal notice should not refer to evidence which the defendant had not elected to deploy in his defence. And that's paragraph 52 and 53. The court said, I've taken the view, and it didn't appear to be contentious, the court can have regard to the existence of the affidavit and the overall nature of its contents without infringing Mr. Vick's right to silence. But I should clarify at this point, the basis upon which he is entitled to take his position is well-established principle of remaining silent, not a compellable witness, the correlate of that right, court required to manage proceedings so as to safeguard that right. Failure to do so will justify the setting aside of an order, even where failure might not have changed the outcome. Case of Hamilton.
I'm sorry to interrupt you, Mr Bogle, but I'm baffled as to the relevance of this, because you've directed our attention to paragraph 53, which is all about the proposition that the alleged contemnor, even if he or she has served evidence in advance in the hearing, still retains the right not to deploy or rely upon that evidence.
Yes.
But in the present case, your client chose to rely upon her affidavits.
My lord, yes.
So what relevance does this have?
It's simply that it was raised yesterday, and I think Malone and agreed it was appropriate to provide the authority from the court. That's it, really.
My lord, I think I may have the answer to your lordship's question. There was this is, I think, goes to the supplemental skeleton argument that was served on Monday, which contained at the end of it a new point.
But that was the Turner and Coates point.
It's a Turner
I think it is
which in the end I didn't understand Mr Bogle to be pursuing.
Well, my lord, I was going to say that at some point this morning that we understood that to have been left floating but not actively pursued. I think the point my lord has just made an argument may be a complete and absolute answer to the Turner and Coates point if it is pursued. But I think that's where we are in terms of the architecture of the applications before the court.
I follow. So,
Bradford, Malone, Fred.
is this right? The Turner and Coates point was raised in the supplemental skeleton. It's not the subject of any existing ground of appeal. It couldn't be ventilated further without an application to amend the grounds of appeal. But frankly, it's difficult to see, as I think you rather accept, Mr Bogle, how it could go anywhere in circumstances where there was an election to rely on the evidence at the hearing.
Yes.
In which case, while it's helpful to see the Deutsche Bank case, I'm not sure we need to spend any time on it.
One moment, my lord. Yes, it was. I take what the point that my lord says, but my lord Justice Arnold quite rightly raised the point as being rather extraordinary that you rely on an affidavit for which there is no cross-examination. But as you say, we've moved on somewhat.
Yes.
The other Jaya House you have. And that's the adverse inference issue. Court cannot draw an adverse inference if the contender chose to remain silent. Question it was dealt with at paragraph 26. And in particular, a reference to the White Book, where it said at CPR 81.28.4, a person accused of contempt, like the defendant in a criminal trial, has the right to remain silent. It is the duty of the court to ensure that the accused person is made aware of that right. And my Lord Justice Nugee asked, was there anything parallel that we could point to in criminal jurisdiction? We weren't able to find anything. But there is something in relation directly to these proceedings. And then it goes on to say, and also the risk that adverse inferences may be drawn from his silence. And that appears from another case, and I'm not sure I have copies. Do we have copies of the video? No. I'm sorry, my lord, we don't have copies of it. They will be supplied. Case of Invidious Limited against Thorogood, a case on the 25th of November 2014 in this court, EWCA Civil 1511, Lord Justice Jackson, Lord Justice Lewis and Lord Justice Tracy. The litigant had not been informed of his right not to give evidence, and the litigation had been managed in such a way that he had no choice but to give the evidence. I pause to say that he did actually give evidence, and that's the difference between that case and this, and indeed the other case as well, that the person relying on the principle had actually given evidence. And that essentially is a reference to paragraph 40. The person accused of contempt, like the defendant in a criminal trial, has the right to remain silent. See Comet Products against Hawkex. It is the duty of the court to ensure that the accused person is made aware of that right, and also the risk that adverse inferences may be drawn from his silence. And again, the case of Hamilton is referred to. So that, in my submission, does appear to be relevant in relation to adverse inferences, regardless of the point about reliance upon the...
So that one, if it becomes available this morning, we'd be grateful for it. Otherwise, I think we can find it for ourselves.
Very good, my lord.
Can we just have the reference to it again? I'm sorry.
I'm sorry, my lord?
Can we have the reference to it
Yes,
again?
of course. (2014) EWCA Civil 1511.
Thank you very much.
And also, if you want the white book reference as well.
No, that's fine. Okay. Thank you.
Thank you, my lord. Well, as regards the main appeal, my lord, I have no other submissions to make on that.
Thank you very much. I ought just to say to Mr. Alquist, he must have a right on the main appeal to reply on what I think is the new case. But I'm not encouraging you to do so. I merely say that you would have the right. I'm not sure it takes matters any further from your point of view.
Well, my lord, I was only going to say one thing about it, which my learned friend did send me a copy of it this morning. I'm grateful for that. It seems to me to be a case which is principally concerned with the fact that the appellant in that situation had faced contempt allegations which were tried at the same time as other matters. That's what my learned friend was referring to when he said the case was managed in a way that meant that he had to give evidence. And the Court of Appeal is strident in saying that won't do.
Yes.
And the findings of contempt were based on, paragraph 42 for the court's later reference, were based on answers which he had given under skillful cross-examination without having been referred to his right not to give evidence. And that it won't do to manage the cases together in the way that that's done, and it was irregular in that case. And my submission is that that's the point, and it's not equivalent.
Well, I mean, it's related to the point that arose in Comet and Hawkex, where the whole point of that case was the Court of Appeal said, prima facie, if you're going to give, as alleged, contempt or an answer to the charge by way of affidavit, you have to submit to cross-examination. But the court has a discretion not to permit cross-examination if it will be oppressive. And in that case, it was oppressive precisely because the applicant was frank that it was going to cross-examine the person in question on issues arising in the proceedings.
Yes, my lord, and having the advantage of having the report in front of me, it's fair to say Comets and Hawkex is the starting point of the Court of Appeal's analysis.
Not surprisingly.
In this case, as is the case of Hamilton and Hamilton, which deals with linking proceedings.
Yeah.
My only real submission is that doesn't assist in terms of what actually happened below. Khan didn't give evidence, and inferences weren't drawn.
Thank you very much. Mr. Bogle, so does that take us to the company's appeal?
Yes, it does. So, my lord, this is the application by the, I'll call them the defendants, to be consistent with my earlier submissions, the second and third defendants, for permission to appeal out of time. It's intimately linked to 868, and indeed, in my submission, if the committal order is set aside as against the first appellant, whom I'll continue to call the appellant, then it will presumably be set aside against the defendants also. Nevertheless, this application for permission to appeal and to appeal out of time has, I think, probably been made out of an abundance of caution in case that were not so, if there were only a partial set aside. But, and in that respect, at any rate, primary submissions have already been made in the main appeal 868. However, there is now a prospective new ground, which I ask your lordships to consider as a matter of permission. It's in effect, therefore, an amendment, draft amendment to the draft grounds, which we're seeking permission for. If I may hand up 3 copies of that, I've already obviously served it on my learned friend. Thank you very much. Your Lordship will see that it's ground 4, and it reads as follows. The judge wrongly included second and third defendants as respondents to the committal order of the 10th of March 2023, when the claimant had expressly in open court told the learned judge that they were not respondents to the contempt application, and the judge acknowledged this both in open court and in his judgment of the 10th of July, which I will be taking your Lordship to. Your Lordship will recall...
Can I just ask a quick question about that straight away?
I'm sorry, my Lord, yes.
Since it arises in my mind. You mentioned yesterday, I think, that this was related to the slip rule application, and I can now see why. But can you help me on this? This seems to be essentially the same application or the same ground as was relied on for the slip rule application, and yet you acknowledge that there had been no appeal against the dismissal of that application.
Yes, for 2 reasons, my Lord. Firstly, as I think the skeleton, as good as, if not as good as, and expressly admits, it was a misconceived application. It should have been an appeal proper in relation to the committal order as regards the defendants. And an appeal against a slip rule application is more or less doomed from the start, it being effectively well within the judge's discretion to say, I may have got it wrong, but that's what I said. It's not a slip.
I understand. Thank you. That's helpful.
So therefore, we seek to appeal out of time on the substantive matter, which essentially seeks to overturn the whole committal order as against the defendants in respect of not only the order itself, but more particularly the cost order contained therein. There's no question. It came out quite clearly in the application before Mr Justice Leech on the 10th of July. That's my client's concern. But it does go beyond that, because the understanding, although there are certain inconsistencies, the understanding certainly of this side of the fence, but in my submission of the judge and the claimant, was that there was no attempt to proceed against the corporates. Although it has to be admitted, they do appear in the N600. So in essence, your Lordship will recall there was an application notice on 24th of May under the slip rule. There were 2, and also to amend 2 procedural orders, because the procedural orders before the actual committal order actually did not contain the names of the defendants as respondents. And
I wonder whether, rather than attempting to deal with this as a discrete matter, you should develop all your submissions. So stage 1, extension of time; stage 2, the grounds of appeal; and sweep up in that the question of whether or not you should have permission on this ground.
Very good, my Lord. So if we go to the single bundle, page 187.
Yep.
the judgment of Mr Justice Leech on the slip rule application. And we are talking about the inconsistency between not only the committal order in and of itself, but also the orders of the 8th of March 2023 and the 20th of April 2023, which do include the defendants as respondents, but not, which don't, and the orders of the 6th of December, 14th of February, 2nd of March and 8th of March, which refer to the appellant as respondent, but the second and third defendants merely as defendants and not respondents to the application. And nothing in the text of those orders in any way qualifies those descriptions. The fact that the appellant is variously and interchangeably referred to as the first appellant and the first defendant in no way alters the fact that she's the only respondent to the second contempt application in my submission. And it's not until the committal order thereafter that a change of heading is permitted to creep in without explanation or proper notice, albeit it does not appear to have been noticed by any of the parties or their representatives at the time, and Mr Justice Leech makes that point in his judgment. So the committal order for the first time begins to refer to the respondents plural rather than simply the appellant singular. It even does so when purporting to cite the 2022 Miles J order, when in fact that order never uses the word respondent at all, but only defendants, both in the heading and the body of the order. And it's therefore submitted the word respondents in the committal order should have read defendants throughout, and reference to the first respondent should read respondent. And any reference to breaches must refer to breaches by the appellant only and not to the purported second or third respondent. And obviously, an order cannot be made, or if it is inadvertently made, cannot, except in rare circumstances, be enforced against anyone who is not named as a respondent. And so in my submission, a cost order was wrong. The whole order was wrong in respect of the second and the third defendants, but the cost order in particular couldn't be made unless a third-party cost order application had been made, and it was not. So if we look at the judgment of the judge on page 189, paragraph 6, beginning the paragraph, piecing together what happened after I delivered the second judgment. He says in the next sentence, it's fair to say that this involved a change in the title to the order because I referred to Ms Khan, the firm, and JFP as both respondents and defendants, whereas in the 4 earlier orders, which I had made before handing down judgment, I referred to the appellant as, or Ms Khan as the defendant stroke respondent and the firm and JFP as defendants. And then in the next paragraph, paragraph 7, he says this, Ms Khan relies on an oral exchange between Mr Olquist and me on the 6th of December 2022, which I treated as a directions hearing. It was originally the original contempt hearing, but it was turned into a directions hearing, in which Mr Olquist accepted that the firm and JFP were not respondents. She also relies on the heading and references in his skeleton arguments throughout the period, right up until that final hearing on the 10th of March 2023. Mr Olquist does not deny that he made that concession, nor that he referred to the parties in the way that Ms Khan submits. But what the judge then says is, however, at no stage did he suggest that he was not asking me to make findings of contempt against them. But my response to that is, neither did he ask for such findings. And it would be unusual to make findings against a party that is not a party to the proceedings.
Well, except that they were parties to the proceedings because the application notice was expressly against them.
But then,
so I think the way you're putting it is not that they weren't parties to the application originally. I think what you're saying is that Mr Olquist thereby abandoned the application as against them.
Precisely that, my lord.
Right.
Thank you for that clarification.
Lord, before we move on, might I ask the court just to read to the end, the rest of the end of that paragraph over the page?
To which I respond by simply saying there is nothing to prevent the court making such findings against a litigant as a director of corporate defendants, but the defendants have got to be respondents to the application in order for there to be an order made against them, regardless of the fact that there might be a finding.
So what you say to the implicit submission that Mr Arquist was making, without making it yet, that he was confused because we can see by looking at the document that they were in fact respondents to the application, and when he said that they weren't, he was simply mistaken, and that can be seen from the fact that he was nevertheless asking the court to make a finding against Ms Khan in her capacity as director of both corporate defendants.
That's the way I would answer that is to say that isn't the position. The position is, as your lordship put it a moment ago, he abandoned the application against the defendants, but that did not prevent the judge, nor indeed Mr Orquist, from asking the judge to make findings against the appellant, or respondent in that case, in respect of her capacity as a director. But unless the defendants, putative respondents, are parties to the proceedings, no order can be made against them, regardless of any findings against the director in her personal capacity. It lays the foundation for such an order, but the foundation founders, unless they are parties to the application, and they weren't, because the application against them had been abandoned. I might say in passing, if there really were an application against the corporate defendants, then the court would expect to hear from the other director, or at least for him to be represented.
There is another director of JFP. Is there another director
of JFP?
Yes, of SK Limited.
Of SK Co? No.
SK and Co. No.
SK and Co, no.
No.
But JFP,
JFP
yes.
there is. Yes.
And you would expect, well, you got my point, you would expect provision to be made to hear from that director, since clearly there will be consequences that would affect him. And they might affect him personally. But there's no suggestion of that at all, my lord. And it wasn't even canvassed. So it's not surprising, therefore, that Mr Orquist decided, well, we're not going to bother to proceed against the respondents. It'll be too complicated. Let's concentrate solely on the first respondent.
When we look at the judge's committal order, it recites that the companies are guilty of contempt, but it doesn't make any declaration that they are in contempt. It only declares that Ms Khan is in contempt, and it doesn't make any substantive order. Obviously you can't commit a company, but you can sequestrate its assets. It doesn't make any substantive order against the companies, it's just a cost order. Is that right?
That's right, my lord. And I think
So your submission is he should not have made a costs order against the companies unless either they were being proceeded against for contempt, which you say they weren't, or clearly you can make costs orders against non-parties, but in that case you need to say that's what you're asking for.
indeed,
Yes.
our lordship exactly has the point. A third-party cost order under Section 51 would have to be made, and it wasn't.
Yes.
But that's not how Mr Justice Leech puts it. What he says is, in effect, that paragraph 22, it made no real difference, therefore, whether the firm and JFP were formally named as respondents, either in the heading to the proceedings or in any order at least until the 10th of March 2023, because the SRA was not seeking any further sanction or relief against them, but they were, in a sense, of a cost order, at least if nothing else. he then goes on to say, at paragraph 23, I was careful not to do more than recite my findings in the committal order and grant any relief against them, including making a declaration. And Mr Bogle acknowledged this in his skeleton. However, it became relevant whether they were respondents because the SRA applied for a cost order against them. Mr Olquist quite properly raised their status and I ruled on it. And Capstick's note does not record Mr Bogle submitting it was wrong to make such an order because JFP and the firm were not parties to the application and that I could not therefore make a cost against him. So he's effectively saying that they are and that we were certainly in part, well, we failed to pick up the point at the time. Now, what he goes on to say, paragraph 24, in my judgment, it's likely that Mr Bogle and Mr Livingston did not object because they took the same realistic and pragmatic approach as the risk defendants, as Gloucester J described them in R&V Versicherung AG against Risk Insurance and Reinsurance Solutions. Mr Alquist showed me the skeleton arguments for the hearings on the 6th and 7th of December 2022, filed by Mr Bogle, and also the skeleton argument which he filed for the substantive hearing on the 1st and 3rd of February. He also showed me the 4 affidavits which Miss Khan herself made and swore. In each of the skeleton arguments, Mr Bogle stated that it was made not only on behalf of Miss Khan herself, but also for the defendants. Moreover, Miss Khan's 4 affidavits were made not only on her own behalf, but on behalf of the 2 corporates. And he goes on to say at paragraph 25, both Mr Bogle and indeed Miss Khan appreciated, therefore, that the defendants needed to be represented at the committal application. And he goes on to say, paragraph 26, it is also clear that I treated both the firm and JLP as respondents. So he goes beyond what my Lord Nugee has suggested, which is that they were simply respondents to a cost order. In the mind of Mr Justice Leech, they were more than that. And he says, and that committal order which I made reflected this fact. And then he goes on to say, well, that's what I said, rightly or wrongly. I can't alter that under the slip rule jurisdiction. Now, going back to paragraph 24, what I say about that is this. The 4 affidavits that were filed purported to be, and we say were, although the judge didn't accept it, a response to paragraph 5 of the order of Mr Justice Miles, which required an explanation as to any documents, or in general terms, what he described as the listed items, that had not been supplied. So that was a response to, in effect, the order of Mr Justice Miles, which was clearly made against the defendants as well as the first respondent, because an original order of Mr Justice Miles only named my client, Miss Khan, and then had to, and a second order had to be made on the application of the SRA to include the 2 defendants. So they were effectively answering Mr Justice Miles's order as they were required to do. And a failure to do that could result, and in fact did result, in a finding of contempt against Miss Khan as a director of those 2 firms, regardless of whether or not they were respondents to the application. So it doesn't resolve the matter one way or the other. Now, it is true there was mention in the skeleton arguments, and I can't remember, but of course I must accept what the judge says, that I said they were filed on behalf of the defendants, but only insofar as it related to the Miles J order, and if I went beyond that, then that was a mistake. That was an error on my part. But the skeleton, the affidavits are a different matter, and of course they're important because they're evidence. So in my submission, the judge hasn't quite got it right there, paragraph 24, or indeed in the order at all.
Can I just be clear? The affidavits we're talking about are the 4 affidavits we were given yesterday.
Correct, my lord.
They obviously had a role in relation to the committal proceeding.
Of course they did, yes.
Is it your contention, as I think I understand you to be saying, that they also satisfied the requirements of Mr Justice Miles' order?
Well, they purported to, but Mr Justice Leech found that they hadn't,
So just
that they
just
were
to be
still
clear,
inadequate. in
the
their
order we're concerned with of Mr Justice Miles is that the one at page 128? With it's paragraph 5 of page 131, isn't it?
That's right, my lord. That's it. I think that's 27th of April. Yes, that's the one. For the benefit of the recording, if the defendants are able to comply with paragraphs 1 to 3 above, the first defendant must, by 4 p.m. on the 5th of May 2022, serve upon the agent a signed witness statement with a statement of truth explaining the steps she has taken to comply, why she has been unable to do so, and when she will be able to do so. And those affidavits were in purported compliance with that.
I'm struggling to understand that submission, because if one starts with the first one, and the position can't be any better for the later ones, the first one was sworn on the 30th of November 2022, and it states explicitly in paragraph 3 that it is made in response to the SRA's committal application dated the 4th of October 2022, alleging breach of the order. So this is not made in order to comply with the order, it's by way of defence to the allegation of a prior breach.
It is that as well, but it is also in compliance with the order of Miles J, as we can see in paragraph 6. And this, what it says there is, the application accuses the defendants of breaching paragraphs 1 and 5 of the order. So the defendants have got to respond to this, not just the first respondent, and of having the listed items, failing to produce the same by the date, failing to serve by the name of witness stated explaining what steps have been taken to comply with the order and why they've been unable to do so. And this, even if it doesn't expressly say so, is an attempt to say what happened and why she's not been able to, and the defendants altogether have not been able to
What
comply.
she says in paragraph 7 is, save as outlined below, I have not breached the order, either in my personal capacity or in my capacity as director of the two corporate defendants.
Yes. That's because it's also a response to the committal application. But you'll see at paragraph 17, reference to JFP, and then at paragraph 19, reference to SK and Co Limited, and just find it, my lord. Yes, well, I can't find it, the particular paragraph I was looking for. But this is made on behalf of both herself and the defendants because paragraph 5 of the Miles J order requires compliance. And she's responding not only in her own personal capacity, but also in her capacity as a director of those defendants, because that will provide the answer to, so she hoped, paragraph 5 of the Miles J order, even if she doesn't expressly put it that way in this affidavit. That's what she's attempting to do.
I haven't quite understood that, Mr. Bogle, because paragraph 1, which is the order to deliver up, is addressed to all three parties, Miss Khan and the two companies. But paragraph 5 of Mr. Justice Miles's order on page 131 requires Miss Khan to provide an affidavit. And you obviously only need one. It doesn't say on behalf of herself and the defendants. It just says she must
Yes.
provide a witness statement explaining the steps that she has taken to comply.
Yes.
So I don't understand why treating the affidavits, as you invite us to, as an attempt belatedly to comply with paragraph 5 is an explanation of the fact that they're filed on behalf of all three defendants, because paragraph 5 only requires her to provide a statement.
Yes, it does. But it also emphasises the point that she's doing so in her capacity as a director as well as in her individual capacity. And she must do so, and in doing so, she is effectively saying what has happened as regards the corporate defendants, she being a director and indeed employee of at least of JFP. So, in my submission, that rather supports the view that I'm putting to your lordship, that they're not respondents, but that she is making a response on their behalf, or at least as a director, and therefore that's why the affidavit is stated in that way. If we go to the next affidavit, it's couched in the similar terms. There's no question that she's there trying to explain how, or is attempting to obey paragraph 5. Because she says in paragraph 3, this is in the second affidavit at page 15, I make this statement in response to the committal application that I have breached paragraphs 1 and 5. And then she says, if I can find it. Again, it's an attempt to explain why paragraph 5 has not been complied with, which coterminously is the substance of the committal application. But all of these are an attempt to, very late in the day, to comply with paragraph 5 of his order. I'm just looking at the third affidavit now.
I think they're all rather of the same kind, aren't they?
They seem to be couched in similar terms, yes, my lord.
My lord, while my learned friend does so, I wonder if I can help at least take one point off the table. I think I ought to say that the case I advanced before the learned judge at the trial was that Khan 1 was a deceitful and dishonest purported attempt to comply. And one finds that indirectly reflected in 112 of the liability judgment. It's taken me a moment to find it. Where the learned judge found, this is page 90 of the core bundle. The learned judge found, I am satisfied beyond a reasonable doubt that the failure to provide any of the information required by paragraph 5 until at the earliest she swore Khan 1 on 30th of November 2022 was a serious, deliberate breach. So I think in answer to my Lord Justice Arnold's point, I think it's the case that everyone below did take this as a purported attempt to comply, albeit that I don't think, without making submissions, I don't think that answers my Lord Justice Nugee's point about the scope of paragraph 5. If that assists.
Yeah, it does assist, yes, thank you.
That's in paragraph 1112.
Yeah.
Of the, on page 90 of the judgment.
Yeah.
Where the judge says, I'm satisfied beyond reasonable doubt that the failure to provide any information required by paragraph 5 at the earliest, she swore Khan 1 on the 30th of November, was a breach of the order. and that Ms Khan's attempt to comply with paragraph 5 was, he says, only prompted by the committal application. Well, that may well be, may or may not be so, but it does show that even Khan 1 is an attempt to comply.
Yeah.
I'm looking at my Lord Justice Nugee to see if that still doesn't satisfy.
Well, we're not, at this stage, we're deciding whether to grant permission, and I understand your argument.
Thank you, my Lord. I shan't press further. So,
So, I don't know whether it's going to help or not. As I understand it, in terms of your grounds of appeal, grounds 1 to 3 are really covered by what you said before.
yes,
Ground 4 you've been developing now.
yes,
Separately from all that, there's a question of extension of time.
yes, I'm coming on to that.
Yes, I see.
So, simply put, the claimants, once the claimant expressly said it was not proceeding against them, they couldn't be made respondents by way of findings, by way, if you like, of a side wind. Still less by simply misdescribing them on the heading of the order. So in my submission, the order should have been directed only against the first appellant, and the learned judge erred in not so doing. I should add that at the transcript, and I think it's at page 22C of the transcript, which is somewhere in the respondent's bundle. Those behind me will find it, I'm sure.
Page 129, the respondents.
So which bundle, please?
Respondents
bundle, my
application
lord.
bundle. This was part of our admission of fresh evidence application. Page 129.
At paragraph A, may I just pick up one point in your judgment, my lord, which I think also is raised in my learned friend's skeleton about the role of the second and third defendants. They are not respondents to this application. Page 129, internal page numbering 22A of the transcript. Mr Justice Leech, no, they are not, but Khan is being, the committal application is made against her in her capacity as the director of the second and third defendants. Mr Alquist, exactly so, my lord, in addition to her personal capacity. Mr Justice Leech, in addition to her personal capacity. Mr Alquist, I just thought I should make that clear, that the second and third defendants are not respondents, my lord. Mr Justice Leech, you are quite right to pick me up on that. I understand the position to be that she faces committal on the grounds that she has committed breach of the order in her capacity as director of both companies, both of the two companies. Mr Alquist, yes, my lord, I suppose I should say committed a breach of the order personally and willfully procured a breach. They are named as defendants in the application notice. Mr Alquist, they are defendants in the proceedings, so they are in the heading, but not as respondents, my lord. I think that covers it. So there, in my submission, it's quite clear it's an abandonment. If, indeed, an abandonment was necessary, it may be that the inclusion of them in the N600 wasn't meant to be to include them as respondents, but that would be unusual, indeed strange, not odd.
Do you dispute that the original committal application was expressly alleging contempts by all three defendants?
Yes, my lord.
So you accept that?
Yes.
Right. So therefore an abandonment was required?
Yes.
Yeah.
But I
And you say this was such an abandonment?
Exactly. That's what we say. It's just I didn't quite understand the wording of Mr Alquist there at D and at C. But in essence, yes, my lord. So an application for an extension of time is, of course, required, as my lord has rightly said. I refer Your Lordship, to the skeleton argument filed. An appeal by a company against the finding of contempt, of course, requires permission in any event, and it's out of time. And whilst not technically an application for relief from a sanction, an application to extend time for filing an appellant's notice is determined in accordance with those authorities, Denton and White, Macadamia, Heiser, and others. And the White Book 52.15.4 addresses it fairly succinctly. And looking at each of the headings contained in the White Book and those authorities, beginning with the first one, is the delay serious and substantial? Well, of course it is. It's 11 months. Is there a good reason? And the reasons are, in essence, the appellant's poor state of health. The appellant is the sole director of D2, the company that no longer trades, and one of two directors of D3, the other being, as I understand it, her brother. It was the appellant's conduct, the judge found, that placed D2 and D3 in breach. Accordingly, their position was intimately connected to the appellant's position, but not, as you've heard me submit, as respondents. The appellant made an error in not issuing an appellant's notice on behalf of D2 and D3 at the same time as she appealed the findings against herself, once again attributable to her mental state and her state of mind. When I say the appellant, I mean whoever filed it on her behalf. We have some evidence that's been put before your Lordship as to what she did or did not do since the committal applications, but it's not entirely clear how much of that was done on her own initiative or with advice and assistance from others. When the appellant realised her mistake, or those advising her at the time, she made another error, again, or those advising her, by applying to Mr Justice Leech under the slip rule, and you've seen what I've said about that. And after losing that application, she failed to appreciate that the company's only remedy was to appeal the 10th of March order out of time. And the appellant's mental state and health, in my submission, are the explanation for that. She has, as we'll see in due course, been recommended for therapy. She's undertaken it. And part of that therapy, she was advised to slow down. She took some time off over July, August 2023, and that during July, the appellant being a devout Muslim, she was fasting for the Islamic New Year, commencing on the 19th of July. There was then a delay in obtaining transcripts of the proceedings and judgments. Requests were made on the 2nd of August, chased up on the 13th of September, but not received until the 10th and 13th of October. And from mid-November and December 23, the appellant had to take a break again as her mental state was again in danger. But the overall primary reason is, once again, her mental state and health. And as regards the circumstances of the case in the round, the second and third defendants also rely on the obvious overlap of the issues in the appeal with those in this application.
Can I ask the practical significance of this appeal for the second respondent, SK & Co Limited, which I think you told us is now dormant?
Yes.
Does that mean it has no assets?
I don't know the answer to that, my lord, and I'll find out.
Because I understand that in principle a finding of contempt is a serious matter, but where you have a corporate defendant and the actual order is a costs order, if you don't have any assets, why does it bother you as a company?
Well, if something's dormant, it can be revived. If it can be revived, it will be revived, save in unusual circumstances, with those obligations still inuring.
Yes, but why would somebody wish to revive a dormant company with no assets if it was simply going to enable a judgment creditor to claim any new assets put into it? You'd start a new company rather than reviving an old one, wouldn't you?
Indeed.
So
there may be reasons why. I don't know what they are, my lord, but it is possible.
but under the third head of the Denton and White,
Yes,
we do have to have regard to all the circumstances.
yes, true.
There is an obvious prejudice to a respondent in granting permission to appeal out of time because they have to face an appeal that they wouldn't otherwise have faced.
Yes,
So you have to weigh that against the prejudice to the appellant of denying an arguable appeal. And then you do, I think, want to know what is the practical downside to the would-be appellant of not being able to pursue their appeal.
well, there's an obvious downside to the respondent who's not making this application, in that it's her name that is on the name of the company. But that's, I accept, a separate issue. But as far as the company itself is concerned, there may be a number of reasons why a company would be revived rather than simply subject to the usual Phoenix arrangements of creating a new company. And if there is it wouldn't be, as your lordship rightly says, sensible to revive a company merely to meet a judgment debt. But if there is no judgment debt, then the company would be able to revive itself without any consequences of that sort. And there could be any number of reasons why a company may wish to revive itself, particularly if, for example, the goodwill of the company, such as it is, hasn't completely dissipated. And that, although the company is dormant, if the company is revived, would become a valuable asset once again. But it would be a valuable asset that was completely expunged if the judgment debt was allowed to stand. And that is but one reason. Perhaps lack of imagination on my part is unable to find others, and it may be that on instructions I can find others. But that seems to me but one of what, even just using general imagination, one can think of as a reason why a company might be restored to the register and want to be restored without any judgment debts threatening it.
When you say restored to the register, has it actually gone off the register? Has it been struck off?
No, my lord, it's as my lord says, dormant. Just check that. It is dormant. I correct myself. It's not actually dormant, it's simply not trading. So that, of course, does make a significant difference. I beg your pardon, my lord, I had misunderstood myself. I thought it was dormant.
And are you able to tell us anything about the practical impact for the third respondent, the other company, JFP? JFP is still trading, is it?
Yes. It is, my lord, yes. It is. It has another director. It has at least one employee who is, as I understand it, a barrister. And it therefore continues to trade. So it's very much a live issue for that company.
One question that might be asked is, if Miss Khan was unable, as you've explained, because of her mental difficulties, to pursue an appeal, might one not have expected her co-director to take the initiative and appeal?
My lord, yes. One might have expected that. Unfortunately, I have no instructions on that. I can seek instructions if that would assist your lordship.
Well, surely it's for your client, the third defendant, to put evidence before the court
Yes, my lord.
in support of its application for an extension of time, if it wants to rely upon such matters.
Indeed, I can't evade that. Well, all I'm told is that he didn't fully appreciate the significance of these proceedings and has therefore taken an account of these proceedings from his co-director, who is, of course, my client. And that's really all I can assist the court with on that matter.
So on extension of time, you fairly accept long delay, but you say explicable by reference to the mental health issues and
A number of administrative matters.
administrative matters and so on. And it's not academic, even as regards Soophia Khan and co, but certainly not in relation to Just for Public.
Your Lordship has summed it up better than myself. So, for that reason, they seek permission to appeal the order out of time, in parallel with the appeal of the appellant. And even if the committal order is not set aside, they would seek to set aside the order as against the defendants. And if that, and in particular, the costs element, but they must go together. It's clear. My Lord, those are my submissions, unless I can assist you further.
That's very helpful. Thank you very much. So, Mr. Arnold.
Thank you, my lords. Just to set out our position in terms of what is and isn't agreed and hasn't been directed. The position as we stood, indeed until about 4:15 yesterday afternoon, was that the company's appeal was restricted to the 3 grounds in the existing grounds of appeal. On that basis, and appreciating that there was an almost exact overlap, and certainly now that they've been argued, an exact overlap with the main appeal, the SRA not only agreed but indeed proposed that it should be dealt with at this hearing, even though it was only filed on the 6th of February 2024, 3 weeks before the hearing starts. The point being that we didn't really need to do anything like file a further skeleton argument, because other than dealing with a few extra points, there was no major substantive difference. Ground 4 is different. And so on ground 4, our position, to deal with it in the order of permission to amend, permission for extension of time, permission to appeal. On ground 4, our position is that permission to amend should not be given. The appeal was only filed a few weeks ago with the benefit of having been settled by counsel. I'll elaborate this properly, but rather than try and do it in summary now. So we oppose amendment on that ground, both on its merits and on the procedure. As far as the other grounds are concerned, grounds 1 to 3, I have 4 short points to make on extension of time, which applies to everything. But I don't propose to address the court any further on the merits. You have my submissions, and I've taken into account what is said in the company's appeal in my submissions on the main appeal. If I can deal, as my learned friend did then, with ground 4 on its merits, the SRA does not accept, and it has not been directed, that ground 4 should be dealt with as part of the rolled up hearing. If the court is minded to grant permission to appeal, and the other permission necessary for ground 4 to continue, then in my submission it would not be fair, this having come through to us only after 10 o'clock last night, to hear the substantive appeal today. Now, that may very well be, and in my submission is, a reason why permission to amend should be refused. But put simply, this is a completely new point, and yes, while I argued the point on the 8th of March, 10th of March last year, and the 10th of July last year, clearly that is different from arguing an appeal before this court, and there's only so much I've been able to do to get back up to speed on it since 10 o'clock last night. What I can do, however, is, I think fairly, is deal with the question of permission. Because on that, a respondent, if this were dealt with on paper, would at most put in that 3-page note under the practice direction. And I am, I think, capable to deal with it at that level of generality. So in our submission, the furthest we can get to on ground 4 today is permission to appeal. I'll deal with that caveat, my lords. I think the next sensible thing for me to deal with is the permission to amend on the merits and permission to appeal together on this point of ground 4, set out in summary what the SRA's case is. And my lords, the ultimate position really is that it's difficult to put it better than Mr Justice Leech did in his substantive analysis in the slip rule ruling, which my learned friend took me to, and I just need to pull back up in the appellant's application bundle. While I find it again, because it's tab 30. Page starts at page 187. And the relevant passage starts at paragraph 3 on page 188. And it refers to the application notice. And it says that it did not expressly identify Ms Khan as the respondent. It is alleged that all 3 defendants had committed the relevant breaches of the Miles order. I refer in particular to box 12 of the committal application to which Mr Alquist took me this morning. He also took me to the certificate of urgency and Crawford 4, made in support of the committal application, which identified all 3 parties as defendants stroke respondents. And just to make that point good, my lords, if we turn to page 35 of the same bundle behind tab 3.
I think it was accepted by Mr Bogle.
It was.
That's a fair point, my lords. Perhaps we don't need to dwell on that and go any further. That's where it is. If the court wishes to see the basis for Mr Justice Leech's analysis. The reality of this situation, as I said to Mr Justice Leech in July, is that I was wrong, as my Lord Justice Arnold says, to refer to the point on the 6th of December that only Miss Khan was a respondent. And the real question, as it appears to have been developed through the argument this morning, is whether that is an error or a concession. And in particular, if it is a concession, because there's a further point, whether it is a concession from which it would be unfair for the SRA to resile.
When did you first seek to resile from it? When did you first say, we are pursuing relief against the respondents'
On the
companies?
10th. We dealt with it orally in court, I think, for the first time on the 10th of March.
After the liability judgment has been handed down.
After the liability judgment had been handed down. And this is recorded in, we had dealt with it in, I think, in the skeleton argument in advance of that hearing, but this is recorded in the set-aside judgment. And one sees it starting at 5, where the learned judge refers to the all orders and judgments he made, and particularly the findings that all 3, and at the end of the liability judgment, it says halfway through 5, at the end of the judgment, that being the liability judgment, I recited that I would make an order that the respondents, plural, were liable for contempt, and that Miss Khan was sentenced to a term of imprisonment for 12 months. Forgive me, models, this is the sanction judgment it's referring to. And having considered the liability and the sanction judgment, essentially what happened then...
I'm sorry to interrupt you, but can I just ask a question? Because I think what you seem to be implying, but not actually stating, and I want to be clear, is that as you accept, you said what you said, as the transcript shows, on the 6th of December. And I think what you're saying is, by the time that it got to the liability judgment, everybody had forgotten about that. And certainly the judge in the liability judgment seems to have proceeded on the basis that the corporate defendants were respondents. Am I right?
I'm slightly hesitant to say assertively everybody had forgotten. Whether and to what extent someone in court might have had in mind what was said on the 6th of December, I can't really say. What I can say, and this is the point I made to Mr Justice Leech in July, is that my learned friend's skeleton argument for the substantive liability trial was expressly filed on behalf of all three defendants.
And that is right, is it? Because looking at the judgments, Mr Bogle is down as appearing on behalf of the first defendant.
I've already conceded that, my lord.
It is right, my lords.
Yes.
There's a limit to what I was able
Yes.
to print, but I can provide that. I have
Sorry, I should correct myself if I made a presented a misapprehension. I was only instructed by Miss Khan. And if the skeleton says otherwise, which I think certainly one of them does, that is wrong. And I said in my submissions it was a mistake. But I was only instructed by Miss Khan.
I'm grateful to my learned friend for his clarification. I don't think it changes the substance of the submission I have to make, which is that the argument advanced was expressly advanced on behalf of all three defendants. The document is titled Skeleton Argument for the Defendants, and the heading of the document also labels all three as the defendants stroke respondents, plural. And what I said to Mr Justice Leech on the 10th of March is that there had been, whether I said inconsistency or confusion or some other similar point, I don't know verbatim when I said we don't have the transcript of that hearing, but I drew the court's attention to the fact that there had been inconsistencies in how the parties had been referred to, that he had made findings of contempt of court against all three defendants, and therefore that in my submission it was appropriate that the cost order may be made against all three defendants. And that's the analysis that Mr Justice Leech went through in looking at the note made by those behind me of the consequentials hearing on the 10th of March. No point on the concession I made, if it was a concession, was taken at that stage.
Sorry, which stage?
On the 10th of March. No one said then, but Mr Alquist, you said on the 6th of December that. I had said there has been inconsistency. The heading has been put differently in different documents. I submit this is the correct position. And the judge agreed it was the correct position that all three had been respondents throughout.
Okay, let me just rephrase that in my own words to see if I've understood the point you're making. So as I understand it, what you say is that given that the judge had dealt with the case against all three respondents in his liability judgment, if it was going to be said that he should not have taken that course because the application as against the second and third respondents had been abandoned in December, that was a point that could and should have been taken on the 10th of March, but it was not. Is that the point you're making?
That is one point that I'm making. The other point, my lords, which follows from that, is that if it is said, and I'm not even sure that it is, if it is said that there was any reliance on the concession that I made, and that the course of proceedings below was altered as a result of it, my lords, that has never been said, as far as I know.
I didn't understand Mr Bogle to say that.
But in my submission, that's an important point if one is looking at this from the perspective of saying a concession was made, should it be determinative?
The starting point is there is plainly a difference between accusing Miss Khan of contempt in that, as a director, she procured a breach by a company, and accusing the company of contempt.
There is, my lord, yes.
It's also, what you said on the 6th of December is not just a confusion about headings. It says several times, in black and white terms, that companies are not respondents. And
yes. But
given that it's now common ground that they had been named as respondents originally, it's not difficult to see that as an election by you, a choice by you, to proceed against only one of the people named in the application notice. And that, I think, is what Mr Bogle is really saying. He's saying, yes, you issued an application notice against all three of them, but before we had the substantive hearing, you told the judge that the application was only going to be against Miss Khan, although you did make it clear that was both for what she had done, failed to do herself, and that she had failed to procure the companies to do. And I'm not sure that you need also to say I relied on that. You just say that's how you chose to proceed, and that's what the liability hearing was. It was a hearing of an application against Miss Khan.
Well, one of the difficulty with that, I take the logic of the point that my Lord Justice Nugee has just articulated. The difficulty with it, and Mr Justice Leech accepted this in his judgment, is that's not actually the correct way of reading that exchange. And I think there is a danger in construing in too careful terms an exchange between counsel and a judge during a procedural hearing about a clarification to something that's been said in a judgment, an oral judgment, that had just been delivered. And if we can go back to 128 and 129 of that transcript in the Respondents application bundle, one sees at the foot of 128.
128.
128. That a procedural judgment had just been given. Now, I've checked with those behind me. We don't believe that judgment has ever been transcribed. It might have to be.
Do you remember what it was about?
It was about, I believe, Mr. Owen's evidence. There was a.
Who's Mr. Owen?
Mr. Owen was the intervention agent. Is the intervention agent. There were various rulings on that day, my lord.
So don't we need to see that judgment? Because you start by saying, may I just pick up one point in your judgment?
Exactly. So
and he says, a point raised in my learned friend's skeleton argument about the role of the second and third defendants. So presumably one would need to see that as well, to understand what the point was.
There's quite a lot more that one would need to see, my lord, if one were to disagree with Mr Justice Leech's decision on the 10th of July about what happened at this hearing.
I mean, going back to where you were at the start, I follow why you say that we can look at extension of time and whether we can look at amendment, but we can't make a decision on the ground of appeal. And the more you talk, the more I think that would be right, because if one got as far as extending time and allowing the grounds of appeal to be amended on this ground, surely a court would need to know more to arrive at a final decision.
Exactly, my lord. But the point on the transcript that I particularly wanted to turn to in relation to my Lord Justice Nugee's question is that what followed from there, and my reference to them being not respondents, is the key passage at C and D, which Mr Justice Leech then refers to in his judgment. I'll go to that in a moment, but C and D. Mr Justice Leech, I understand the position to be that she faces committal on the grounds that she has committed breaches of the order in her capacity as a director of both defendants, both of the two companies. And I, perhaps pedantically, but importantly, corrected that summary and say, I should say she committed a breach of the order personally and willfully procured a breach. Now, that's a fairly shorthand way of making the point, but willfully procured a breach by the companies.
Yes, but there's still a difference between seeking to commit a director on the grounds that they have procured a breach by their company, the company being under an obligation by virtue of an earlier order, and seeking to commit a company for a breach. The difference is obvious, because you can send the director to prison, but if you find a company to be guilty of contempt, you can't send the company to prison, but you can sequester its assets. And so
that's
one does
point.
need to know whether the respondent is the director herself, or is the corporate body as a corporate body. And although, as I say, it's clear that the application was originally issued against both, this does look to me on its face as a decision by you that you're only proceeding against Miss Khan, qua director, on the grounds of procuring a breach, and not on the ground, not against the company.
Well,
now, I'm going to echo what my lord said. It has become apparent to me that you can't, or it's difficult for you to say that your case on the merits is so strong that permission for that reason should be refused.
Well, I recognise where the court is going with this. If I might just finish the submission in answer to my lord's question. Essentially, what I was saying, and if one looks at the 10th of July judgment, this is how Mr Justice Leech understood my submission, is precisely that point that no order was sought for sequestration or fines against the second and third defendants.
But you did ask for and obtained an order for costs.
And we did say, and I said on the 6th of December, that we were advancing the case that they had breached the injunctions. And that was the point that was picked up in the liability judgment. And then on the 8th and 10th of March, I said to the court, there's been some confusion about this in the past, but looking at what's happened, we think the correct answer is there should be a costs order against all three defendants. And the judge accepted that. That's where we were, and that's why Mr Justice Leech, on the 10th of July judgment, not only found...
Wait, sorry, can I tease out what you were saying there? Is the submission you're making there related to the one you made earlier? Namely, at the point when you asked for the costs order against all three defendants, that was the time for them to take the point, well, hold on, two of these are not respondents, but they didn't. Is that the point you're making?
I can't recall, my lord, whether they said two of these are not respondents. My submission earlier was that they didn't say Mr Alquist conceded they weren't respondents.
I mean,
Once
then
again,
we come back to the fact we don't have a transcript of that. We don't have your skeleton or skeletons in relation to the February and March hearings. We don't either have Mr Bogle's skeletons.
No. And that's why I say I can assist on the equivalent of the 3-page note, but it would be an ambush to deal with the substantive appeal today if permission is granted. I recognise the difficulties. I think I've said everything I've said. I need you on the merits. Obviously, the last point on ground 4, permission to amend, and I canvassed this very slightly in my overall introduction, the appeal was only filed 3 weeks ago. It was settled with the assistance of counsel and with the benefit of having gone through the slip rule application and his lordship's judgment on that. If this ground had been put in then, we may have been able to assist the court, and therefore as a matter of case management, when considering the question of application to amend on grounds of appeal that were articulated only on only intimated that they were coming on day 2 of a 3-day hearing, this court should consider whether it is right to allow this company's appeal to be effectively go part heard, so that this question should be dealt with. In my submission, it would not be. That's everything I need to say specifically on ground 4,
Yep.
and all that remains is the application for an extension of time. We've dealt with this paragraphs 93 to 95 of my consolidated skeleton. There are only sort of 4 headlines essentially to take. The first point is that, to be clear on how the application is put, the companies have accepted not only that there was a serious and substantial default in failing to meet the deadline, but that there was no good reason for that. That's 17 of the company's skeleton argument. Single bundle, tab 3, page 20. 17 to 18. 17 is the acceptance of the serious and substantial breach. 18 is the acceptance that there was no good reason for delay, but that the mental health and more generally the diagnosis make it an understandable breach. Whether it's, I suppose therefore the health is given not as a good reason for the delay, but as part of the general justice of the case, under the 3rd heading of the factors we all know very well. But looking at the delay, in my submission, the mental health does not give any explanation, let alone constitute a good reason. And the reasons for that can essentially be summarised in 2 points. Firstly, that the slip rule application was dealt with and heard from its initially being raised in April to the judgment on the 10th of July. And it was repeatedly made clear through not only in the judgment but also during the course of argument that the proper approach would have to be an appeal. I put the references in paragraph 94 of the skeleton. It's 26 to 27 of the learned judge's judgment. I don't think we need to turn it back up. But the point is clear. Ms Khan could have been under no misapprehension at that date that the correct thing to do was put in an appellant's notice. Why was there a further 6-month delay before the companies put in any application for permission to appeal at all? And why wasn't this point included even when they did? There's no explanation for that, except that paragraph 19 and some of the, which my learned friend took you through, and the evidence in the appellant's notice, suggest a few explanations for various bits of time off work, religious observance, and so on. But the key point is that during that period, Ms Khan clearly was capable of making applications, including applications to this court, because we have on the matters before this appeal, late July was one of the periods in question. October to November is another period in question, where religious observance and time off work are cited. There is an application on the 26th of July 2023, which we have in the Respondents appeal bundle, tab 34 of the exhibit to Hodgson 1. That is the request for reconsideration of my Lord Justice Newey's initial refusal of an extension of time in the 2022 appeal. And we have another application, in fact on the same point, on the 22nd of November 2023. That's this appellant single bundle, tab 13, page 70. We probably don't need to turn them all up. But there's a lot of correspondence and communication with the court, submissions filed and so on, throughout that time when it is said that there was a justifiable excuse for not having put in this appeal. And in our submission, that just doesn't work. I don't quibble at all with what Ms Khan says about the importance of taking time off work or the importance of her religious observance. Of course not. But the fact is she could indeed make applications during that time. And finally, the point on which I suspect nothing turns, but particularly on grounds 1 to 3, we have referred the court in our skeleton argument to the authority in Lacatamia and Sue, where it said that in fact on the application for an extension of time, in a sufficiently clear case, you can take the merits into account. I suspect nothing turns on the point of whether the court case takes the merit into account, given how this is listed, on the extension of time or permission to appeal. But having heard 2 days of argument on effectively grounds 1 to 3, it may be, if you're not satisfied, there's a real prospect of success. It ought to be a reason to refuse the extension of time on the authority of Lacatamia and Sue. Unless I can assist the court further, I think, anything further, those are my submissions on the applications in the company's appeal.
Do you want to say anything about the points that the court raised about the potential prejudice to the companies?
My lords, I am not sure I can. Those behind me have helpfully provided me and shown me where we can find the accounts of the 2 companies. I have question marks over the figures, some of the figures that are put in the accounts. I'm not entirely sure I want to refer the court to evidence you don't have, particularly where I'm not entirely sure about how the figures have been brought up. But they are both on the register. They are both filing accounts. And I agree, JFP appears to be an active business. It's established as a non-profit entity, we're told, but it is an active limited company. SK & Co was intervened in and therefore cannot properly be trading, certainly as a solicitor's firm.
Thank you.
I think that's probably all I can say. From our perspective, of course, it is actually important if there are assets there and we are entitled to a costs order, then it's right that we obtain that so that we can seek to recover those assets rather than have the cost of these proceedings borne by the profession as a whole. Those are my submissions.
That's very helpful. Thank you very much. Mr. Vogel.
I
Any
have no
points in
submissions,
reply?
Arnold, unless is anything that your lordship wishes me to
No, I,
address you on.
subject to any questions from my brethren, I think we've got the shape of this very clear.
May I ask for a 5-minute break for my client?
Are we still comfortably going to finish by 1:15?
I shall make sure that I do. Well, of course, my learned friend has got a reply.
Yes.
I shall nonetheless make sure that I am brief. I will need to therefore be no more than 20 minutes, really.
On that basis, I'm happy to rise for 5 minutes and still finish by 1:15.
Thank you, my lord.
All right.
The schedule is 2 to 3 days. The timetable agreed allocated the afternoon for judgment and consequential.
Right. Okay, so that's where
They may have decided to reserve judgment, but not want us to take them
yes,
on.
we may have different views. My assumption is that whatever we
Maybe efficient case management.
Mark, bring a pen.
I'm just going to sit and read my notes on the jurisdiction of the Court of Appeal to reconsider its
No, 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 no.
recipe, whatever you want to call it. Is your understanding that today is just an application for permission to file a temporary rolled up hearing for the whole appeal?
It's not a roll-up hearing.
Yeah, that's
we
fine.
have a file discussion.
It's
It's
So
not.
the reasons you said, neither can ground 4 be, because you've only got ground 4 today.
yeah, look, I'm technically not instructed on those two appeals, as you know. I'm just trying to.
Oh yes,
Just
sure.
it's
trying to
not
assist.
it's not an application for an extension of time either.
It's a renewal application against
Well,
his
it's
a
an
set-aside
application to
application.
set aside the decision on reconsideration
Yeah.
of the initial refusal.
That's right.
Yeah, no,
That's it.
I understand that.
Yeah.
I've got that. But it's,
Actually,
there was
to which
but
sequence.
I was just double checking. You weren't planning on us launching straight into a substantive appeal on that point. No, fine. Just 'cause-
It's a slightly different point
yes.
from the main appeal.
Yeah. No, of course it's a different fact.
Yeah.
Like,
All rise.
Well, thank you. I'm most grateful. This is the appellant's application to set aside your refusal to reconsider your order of the 17th of July. Your Lordship will recall there was a 17th of July order followed by, well, actually, sorry, the 14th of November, which in turn was a confirmation of the 17th of July order, and permissions sought thereunder, the applications were dismissed. And there was also your unless directions order of the 3rd of October and directions on the 13th of February for this application. The original application notice of the 2nd of May, which is the respondent bundle, page 281, she seeks to set aside refusal to reconsider permission to extend time to file an appeal and to rely on the evidence of Dr. Rajpal pursuant to CPR 5221(2)B. And your Lordship has already seen those reports. In particular, they say that she struggles with rigidity of thought, reduced ability to consider options and the possible consequences of her actions in complex and stressful situations, and that the ASD deficits might have impacted her ability to decide the appropriate course in August, September and October of 2021, particularly if she was suffering what has been described as autistic burnout, which Dr. Rajpal gives some description of, and appends an appendix which sets it out in more detail, which can have very serious consequences on the mental capacity and mental ability of the person. She's only recently been diagnosed as to her condition in 2021, although, of course, we know from Gupta 2 that this has been more recently a problem. Gupta 2 doesn't. The problem with Gupta 2 is it doesn't set out any dates. It is, as Mr Justice Leech rightly says, a rather terse and incomplete report, but doing the best that he could in the time that he had. That is what he said. So once again, it's back to my earlier submission that more information is needed, more medical expertise. And the delays are explained by her condition, which often means she can't focus, concentrate, cannot give instructions, has to take time off, and often cannot understand what is needed of her. And all of this can only be understood after full and proper medical evidence. At the time of the adjourned application, on the 17th of December 21, all she had was the letters from Dr. Chowdhury, and that, of course, didn't go anywhere near indicating what has since come to light in Gupta 2 and from Dr. Rajpal. Now, of course, Mr. Justice Leech can't be criticised for that. But what he can be criticised for, we say, as an error of law, is a failure to obtain further medical evidence. Then came her reply submissions, where she repeats what she said, of course reminding us that there was no previous appeal against liability, so this is brought out of time. There was only an appeal against sentence, which was unsuccessful. And she's since provided 3 reports from Dr. Rajpal, the 14th of April, the 8th of June, and 30th of September, which again reiterates that she's suffering from a neurodivergent and cognitive set of defects impacting her decision-making at the relevant time in August to October 2021. And so, on that basis, he challenges paragraph 40 of the Leech judgment of the 12th of January 2022, and says that accordingly, although once again I must make my familiar submission that more evidence is needed, there wasn't a deliberate breach in the sense that it is now meant when we speak of contumely and contumaciousness of the order, as Mr. Justice Leech, contrary to what Mr. Justice Leech found at paragraph 50. And I add here that in the absence of full and proper medical evidence, the court did not consider, given her mental state, if it was impossible mentally for the appellant to comply with the order. And in my submission, an analogy can be drawn with the case of Sectorguard against DN PLC, which I'll take your lordship to, if I have copies, I hope we do, where it was held that if it's physically impossible to comply with an order, then even if there is the actus reus of contempt, there cannot be a finding of contempt. But impossibility can be psychological as well as physical, just as harm can be psychological as well as physical. Now, of course, Mr. Justice Leech did not consider that at all, even in the light of Gupta 2 much later in the second appeal, but in the first appeal either. And since we now know that that is, I now submit that is an important factor. It was an important factor then, or could have been, and he wasn't to know until he got that medical evidence that he refused to get. May I hand up copies of Sectorguard?
Yep.
I perceive my learned friend has. I sent him a copy this morning. I hope that arrived satisfactorily. Briefly then, this was an application of the committal of the directors of a company for a failure to comply with an undertaking, was struck out as an abuse because on the documentary evidence it had no real prospect of success. The undertaking on which it was based was incapable of performance. And in essence, the application having been granted, failure to perform an impossible undertaking was not a contempt. The mental element required, and I underscore the mental element, required of a contemptor was not that he either intended a breach or knew that he was in breach, but only that he intended the act or omission in question and knew the facts which made it a breach. And this is, of course, the point that my learned friend has made. Nonetheless, said the court, even a modest element like that assumed an element of choice. An omission to do that which in truth was impossible could involve no choice at all. Failure to comply with an order to do something, where the doing of it was impossible, could therefore could not therefore constitute a breach. Could constitute a breach of the order, but not a contempt. The case is essentially about that throughout. Conscious of the time, it's under the heading abuse of process.
I can certainly see paragraph 32. I accept the thrust of Mr. Grant's submission that failure to perform an impossible undertaking is not a contempt.
That's it. That's the one. Thank you, my lord. And so what I say is that although in that case there was a physical impossibility, the company was simply not able to produce the goods that the mandatory order had required them to produce. But in my submission, that must equally apply to psychological impossibility, just as harm can be psychological as well as physical, for example, in negligence or assault or other areas of the law, particularly as the law has developed. In any event, be that as it may, the appellant's failure was caused by neurodivergent cognitive deficits and not deliberateness. And further and better medical evidence is needed to determine with sufficient cogency, and I don't wish to criticise Dr. Rajpal or Dr. Gupta, but in the circumstances in which they produced their reports, necessarily the cogency was not what the court required, then further medical evidence is required. In the same way as in the second contempt, so it applies mutatis mutandis to the first contempt. There then came the application notice of the 30th of June, sought an extension of time, and then an application notice of the 23rd of August seeking further time, and then eventually the amended grounds. And quite rightly, my lord said, well, I can't amend grounds when the appeal is not live, but if the appeal became live, they would be sought. Dr. Rajpal describes autistic burnout as very much possible, but cannot comment on fitness to plead in December 21. But his report does go to the issue of reasonable adjustments, and there don't appear to have been any reasonable adjustments made at that time when it appears that the appellant was suffering from autistic burnout. But very much possible, again, isn't enough, really. More medical evidence is needed to specify that. And also to be more precise, if they can, about dates and times, because clearly that's going to be crucially important to the decision of the court in respect of both contempts. And so once again, I say clearly fuller and medical and further medical evidence and examination is required. The issue of autistic burnout, dealt with briefly by Dr. Rajpal, is that he says it's an experience commonly described by autistic people. It's a novel concept, not a novel phenomenon, clearly, and those who suffer from it describe debilitating exhaustion with onset related to various stresses, including masking, though several differences exist, such as the characteristic of interpersonal withdrawal. And it is frequently misdiagnosed as other conditions like bipolar or borderline personality disorder, but is in fact a freestanding, or at least appears to be a freestanding condition in and of itself. And on the 16th of November 2021, which is directly before the application, the appellant reported signs of exhaustion and tiredness, and that she was having problems concentrating and finding it difficult to prepare for the latest hearing, which was listed on the 23rd. Now, all she had at that stage was Dr. Chowdhury, and his assessment was nonetheless significant to this extent. She is unlikely to be in a mental state to prepare, attend, and make representations for this hearing, as we saw. And he made a referral to a psychiatrist in view of her current mental state. So, Mr Justice Leech was on notice on the 15th of December 2014 that the appellant was potentially litigant in need of reasonable adjustments and further medical evidence was needed. And as regards the adjustments, that appears to be at odds with what is set out in the Equal Treatment Bench Book, an extract of which I have set out or attached to the authorities bundle. But nonetheless, Mr Justice Leech found at paragraph 64 of his judgment that although the appellant's mental health condition could not excuse her conduct, nevertheless he said this, interestingly, it did go some way to explain why she adopted such a wrong-headed attitude to the intervention and to the subsequent court orders. All right. In the bundle at tab 12, page 297, is the case of Rackham against NHS professionals, a decision of the Employment Appeals Tribunal. Tab 12. So page 315 is what I'm looking at. Paragraph 45. Well, it begins at 32. I'm sorry, that's back at page 311. We do not think it could sensibly be disputed. A tribunal has a duty as an organ of state, as a public body, to make reasonable adjustments to accommodate the disabilities of claimants. Ms Joffe accepts and indeed submits the particular route by which the obligation rests upon the tribunal is unimportant, though it might be one of a number, because there can be no dispute that there is such an obligation. It may be, as Mr Horan submits, through the operation of the United Nations Convention by the route he suggests. It may be by operation of the Equal Treatment Directive, or it may arise simply as an expression of common law, fairness. And then back to page 315, paragraph 45. It might be thought that enabling a party who might not, by reason of disability, be able to adequately participate in a hearing, just as someone with limited language or comprehension might be unable, would therefore be an essential matter of fairness open to review on appeal. However, in this case, the decision would be bound up necessarily with a consequential decision whether the case should be postponed to enable further inquiries to be made. Such a decision viewed on its own would normally be treated as a case management decision. Ms Joffe submitted that, in effect, a decision such as the present should be treated as a hybrid. She had in mind the words of Lord Steyn in the case of Daly against the Secretary of State for the Home Department, 2001, the second volume of the appeal cases, 532. In particular, paragraphs 27 to 28 thereof. In paragraph 27, and I'm now at the top of page 316, he noted that in this field dealing with the question of fundamental rights, the starting point is that there is an overlap between the traditional grounds of review and the approach of proportionality. Most cases will be decided in the same way whichever approach is adopted, but the intensity of review is somewhat greater under the proportionality approach. Making due allowance for important structural differences between various convention rights, which I do not propose to discuss, a few generalizations are permissible. I would mention three concrete differences without suggesting that my statement is exhaustive. First, the doctrine of proportionality may require the reviewing court to assess the balance which the legislation has struck.
There's been a great deal of subsequent authority on that question, including the recent decision of this court in the Dalston case.
Very good, Lord.
Handed down, I think it was either yesterday or the day before, where Lord Justice Singh goes all over this, all over again.
Very good. All right, I shall move on. So what I do say, though, is that what it says, I shan't take you there, but paragraph 36, it makes reference to the Equal Treatment Book, and all I say is that reasonable adjustments should have been made. The other thing that Dr. Rajpal says, which qualifies his report to some extent is that he says that he can't make a quantitative assessment, but he says there are no scales that can quantify the manifestations of autistic traits. And he couldn't say with qualitative assurance and or quantify the impact of the increased manifestation of autistic traits and deficits on the appellant's decision-making process in relation to the orders of the 7th and 21st of December. They can vary in the same person depending on the situation. My submission, that again calls for further medical evidence to clarify that point. Simply to say they can vary isn't going to be an awful lot of assistance without more. But what he does say is that autistic burnout is an intense physical, mental and emotional exhaustion which can make a person on the autistic spectrum struggle with day-to-day tasks, lose executive functions, and have a reduced tolerance to stress, all increased where the person is without adequate support. And it wasn't until she began therapy in April of 2023, and during that session, that she began to learn of her condition, the appellant, and how to make adjustments, because this as concept, it seems, is a new concept. But in essence, the delays are all attributable to the appellant's condition. But really what it boils down to, my lord, is that full and proper medical evidence is required in the same way as I submitted in respect of the main appeal. And in some respects, the two hang together. And I would urge upon your lordship to consider it in that way and not to, as it were, sever the two contempt applications and contempt findings unduly. It depends what further medical evidence will say about how far back her autistic condition and particularly any burnout and any inability to be able to plead, to be able to take part in the proceedings, to be able to stand trial, to be able to give instructions, goes. And that, on the present medical evidence, isn't sufficient to answer that question. If and when such medical evidence is obtained, it will not only answer the question in respect of the main appeal, but in my submission also in respect of this application to set aside your lordship's refusal to reconsider. And you've already seen the consolidated supplemental skeleton, so I shan't trouble you with that. Well, those are my submissions, unless I can assist you further.
That's very efficient, Mr. Bogle. Thank you very much. Mr. Alquist.
Thank you, Mose. I will endeavour to be equally brief, although there is one point of some complexity which my learned friend hasn't touched on that I feel I need to deal with, which is jurisdiction. But dealing with the points that my learned friend has dealt with first, there have been submissions this morning by reference to authority about both, new authority, about both the impossibility of a breach at all and whether reasonable adjustments ought to have been made. I think it is important to emphasise the point that those are not part of the grounds of appeal in the 2022 appeal, and just to make that point good, if we turn to the Respondents supplemental bundle, this was part of our application in the main appeal, tab 24. And turn to page 292. Firstly, there's nothing here about reasonable adjustments. It's said that there should have been an opportunity to obtain expert evidence relevant to liability. And in particular on the grounds 2 and 3, that the fresh evidence shows that the test for contempt of court was not met in the face of the evidence that is relied on. Now, in our submission, my Lord Justice Newey was right for the reasons he gave and had been set out in our skeleton argument, that the fresh evidence did not engage with the relevant test and did not support the conclusion that the relevant test for contempt of court was not met. And while trying to be relatively brief on this, I'm conscious that the court, from the discussions we've had previously, knows full well the decision in Varma and Atkinson and the status of having overruled or disapproved the decision in Telly, to the effect of which it is not necessary to show that a contemner knows that they are in breach, only that they know of the order and they know of the actions, and then that the effect of those actions is to put them in breach. That's the Varma and Atkinson test. The references, my lords, are all in the skeleton argument. It's so well known in both of Mr Justice Leech's judgments. I don't think we need to turn it up. But if one then looks at Dr Rajpal's evidence, which one can find in, to start with, in the same bundle, the Respondents application bundle, at the following tab, tab 25, first of Dr Rajpal's report.
Page.
The relevant page is 297. This is the high point of my learned friend's case on expert evidence as to suggest that something more needs to be had. Paragraph 1.4 at the top of 297. In her case, her diagnosis would not impair her ability to form mens rea for her actions. I recognise this is a brief report and it doesn't go into the question of what the mens rea, if that's the right phrase, for contempt of court is, but certainly you can derive no support from this expert report for a contention that it was not possible, as my learned friend said this morning, for Ms Khan to breach the orders, or that it was not possible for her to be aware of any breach of the orders, even if you take the Telly style analysis, which has been disapproved, which the grounds of appeal implies correct, as in they imply that they're relying on the Telly style argument. Nothing in 1.4 or 1.5 or 1.6 goes to the question of whether Ms Khan knew that she was in breach of the court's order. It talks about rigidity of thought and ability to see different options. And it might on balance have impacted in her ability to decide in August, September and October what to do, but it is not possible to quantify it. And that not possible to quantify was then the subject of the addendum. He said, well, it's a qualitative rather than quantitative analysis. The court has heard detailed submissions this morning about autistic burnout as well. It's worth being very clear about what Dr. Rajpal says about that. And this is tab 37 of the single bundle filed by the appellants. Now, the relevant page, my lords, is 248. I'm not going to advance any positive case one way or another about whether autistic burnout is or isn't a concept. I don't need to. Or is or isn't a valid concept in medical analysis. But what is Dr. Rajpal's evidence? Well, it's that it's a rather new concept, he says in the first line of 5.1, described recently by some people working in the field. In the next paragraph, it has been conceptualized as resulting from chronic stress that people with autism suffer from, having to live, work, and engage in a world not designed for them. The probability of this happening is designed to increase in people without adequate support. And it's connected in the paragraphs that follow to the diagnosis of stress in November and December 2011. He then concludes at the top of the second main paragraph, it is very much possible that Ms. Khan had some signs as being described as part of an inverted commas autistic burnout. However, as mentioned, it is a rather new concept, still being described and researched, and it is not possible to comment on the severity of such, on her ability to being fit to plead, engage, and instruct her team for trial on the 17th of December 2023. Autism itself is not enough for the defendants to become unfit to plead, engage, or instruct. And in my submission, therefore, my Lord Justice Newey was plainly right when he said on the 14th of July and on the 17th of July and the 14th of November, that neither the original report nor the supplemental report actually support any articulated basis for appealing against His Lordship's order. They don't engage with the Varma and Atkinson test, and in fact they don't, particularly as regards autistic burnout, they don't support the medical case in as fully as my own friend's submissions might suggest. I don't think I really need to say any more on the merits. Safe to say that we've put this in more detail in 80 through to 84 of our consolidated skeleton with all the relevant references. And indeed also the point about Varma and Atkinson having been dealt with not only in both of the appeals at first instance, but also by my Lord Justice Arnold indirectly in his decision in this court in the first appeal, where it was rejected, the submission was rejected that the learned judge had failed to give proper weight to the medical evidence. The other 3 points I need to make, my lords, can be dealt with quite, well, 2 of them can be dealt with quite shortly. Firstly, we say, my Lord Justice Newey, I'm going to do this in reverse order, if only for the efficiency. My Lord Justice Newey was right to take into account the fact that the sentence has already been served.
I have to say, I see that sentence in one of these orders. I can't remember which one. And I've seen debate between you as to whether the fact that a sentence has been served is of itself something that can be taken into account. At least one element of what I had in mind was I'm concerned with delay, and I thought, I don't properly remember, but I think I thought that, well, it might be more difficult to do these things in prison, but once you're out of prison, it's easier to do them. And insofar as I thought that, it doesn't really engage with the debate between you as to whether or not, when a sentence has been served, it's appropriate to allow something to go forward.
That's correct, my lord. The point which your lordship indicated you may have had in mind wouldn't engage with that debate. It would be a freestanding point within the subheading of delay.
Because, of course, what I was concerned with was not actually primarily the merits of the proposed appeal, but whether or not there should be an extension of time.
Yes, that's the only point.
That's the only point I was actually ultimately concerned with, and in that context, so I was looking at how long the delay had been and what reasons there were for it.
Yes, my lord. And the reason I was going to mention it first was to say I don't really think I need to go into much more detail than is in our skeleton argument. We do say, if you're looking at all of these points in the round, the fact that liberty of the subject is no longer in question is a relevant consideration under the overriding objective in whether there should be an appeal. Particularly whether there should be a second appeal, there already having been an appeal touching on medical evidence and indeed squarely dealing with the medical evidence before this court last year. And again, I don't think I really need to say much more than is said in our skeleton arguments and our previous submissions to my lord
So the point,
on abusive process.
the point that you're flagging up, you might want to say more on is the jurisdiction point.
Yes, my lord. And I want to say more on that because in my submission, points that go to jurisdiction, it's important that the court gets them right. And I should therefore make your lordships aware of the concerns we have on this point. Of course, one might say, and I don't want to write the court's judgment, but it could be said, jurisdiction question is interesting, but actually, in any event, the decision was plainly right, so we're not going to entertain it and get into the question of jurisdiction. But I should address the court on it in case that's not the court's approach. And the point, without turning to the authorities just yet, is this. The court has refused an application for an extension of time, and therefore the appeal stands as dismissed. The court has then been asked to, and has reconsidered its decision under the specific statutory regime for it doing so. Is there jurisdiction, or alternatively, if there is, on what basis should it be exercised, for this court then to hear a further application on the same grounds. And it's important to emphasise that it is on the same grounds, because my learned friend has, quite rightly, as this is his client's case, essentially argued the merits again. The merits of the application for an extension of time, and in part, in relation to that, the merits of the proposed appeal. It is not said that my Lord Justice Newey committed any procedural irregularity which vitiates the effect of his reconsideration decision or his original decision. This isn't a case where there's been a change of circumstances or the court has been misled. Nothing of the sort, of any of that. So the question really squarely arises, can this court be asked to have a third look at the same point? And one of the points in this, my lords, is, well, under what rule is this application in fact made? It was originally made under CPR 3.3.5a, which concerns the reconsideration of orders made without a hearing of the court's own initiative. Would it assist the court to turn that up? So this is all.
What was it again?
3.3.5a. This is page 90.
80 something, isn't it?
88.
Oh, yes. I was going to 3.5.
88. 3.3
Yes.
sub 5.
88.
And that takes you back to 3.34, which is the court making an order of its own initiative.
Yes. So, my lord, the basis on which the application is put, originally 3.3.5a, doesn't apply. The court did not make an order of its own initiative without hearing the parties. It was asked to make an order. Now, the supplemental skeleton, which was filed on Monday, raises a slightly different basis, which is that as regards my lord's refusal of the permission to rely on Rajpal 2, whatever the number is, the 30th of September Rajpal report, there was a Part 23 application notice and a request for a hearing, and the application was instead determined on paper. So it is said as regards that one, and I think now that the appellant has corrected the basis on which the appeal is put, I think that must be right. That in the ordinary way, it's not 3.3.5, it's Part 23. It's either 8 or 10. Let me bring that one up in a moment. It is, well, it's both really. If we turn it 23.8 is 656 of the White Book, which provides for the basis on which an application may be dealt with without a hearing, which is the parties' agreement, either to the terms or to the application being dealt with on paper, or 23.8c, the court does not consider that a hearing would be appropriate. There can be no criticism of my lord for dealing with it without a hearing, but it might then be said that under 23.11, I'm slightly trying to fill in the gaps of the rules that have not been fully cited in the application. But I believe it's 23.9, but I can't, just looking at the rule, I can't find it. Well, I don't want to spend too much time looking to fill in the dot in the step of an analysis which ultimately in my submission takes us nowhere. I accept there is ordinarily an opportunity where an applicant asks for a hearing and the court makes an order without it, then an applicant has an opportunity to say that that order should not have been made in that way and there should be a hearing.
I think what you want is practice direction 23A, paragraph 11.2, on page 667, which says where Rule 23.8c applies, the court will treat the application
Yes,
as if you're proposing to make an order of its own initiative. Now, if you go back to page 657, you'll see the final paragraph as a note at the top half of the page explains that the significance is that where the court makes an order under 23.8c without a hearing, the right to apply to have it set aside conferred by Rule 3.35 accrues.
Exactly. My Lord has the link that I couldn't find between 23.8
It still raises a question of whether that's displaced by the particular rules applicable to this court in Part 52, which is 52.20. 3.5, is it?
Or is it 24?
24.
Yes, my Lord. And there's actually a prior question as well, 24.6. There's a prior question which is this, and this is why I was going to say it doesn't ultimately matter. Unless my Lord Justice Newey's refusal to extend time is also challenged, it is also successfully challenged, the question of whether expert evidence should be adduced is moot. So the point raised in the supplemental skeleton, which we've just been identifying about 23.8 and 23.10, doesn't take the appellant anywhere unless the extension of time decision is also successfully challenged. And that takes us, as my Lord Justice Nugee says, to
52.24.
52.24.
I mean, can it
24.6. Yes.
Can the basis of this simply be 52.24.6? The first decision can be reconsidered. The second decision can be reconsidered.
Well, my Lord, that's the question which I think needs to be asked and isn't grappled with at all by my learned friend's submissions or the application. Can a reconsideration decision itself be reconsidered?
I mean, it's within the strict terms of 52.24.6, is it? A party may request a decision of a single judge made without a hearing
To be reconsidered.
to be reconsidered.
Yes, well, it is. But
So you have to say it's implicit in that you get one reconsideration, and if that's dealt with by a single judge without a hearing, that's tough. You can't open it again.
the rules expressly provide that it will ordinarily be dealt with by a single judge without a hearing. Indeed, they expressly say that it may well be the same judge.
I mean, just jumping around, with the 52.30 jurisdiction, the reopening of a refusal of permission, I think this court accepts that you can ask and ask and ask again and again and again. So it wouldn't be so anomalous if it were also possible to ask again on a 52.24.6.
Except, Miles, that if one were to do that, well, I say there are two questions, as I articulated at the start. The jurisdiction heading deals with both. Is there a jurisdiction, and if so, on what basis could it be exercised? And I accept there is nothing in 52.26.4 which says you can only have one shot, and I accept the practice of the court under CPR 52.30, the Taylor and Lawrence jurisdiction, is to permit sequential challenges if need be. But of course, the threshold on Taylor and Lawrence is exceptionally high. I don't mean exception as in it needs to be an exceptional case, because that doesn't really tell you anything.
It does need to be.
Well, yes, well, I had in mind that the Supreme Court's disapproved that in another context, saying, well, it doesn't tell you anything except how rarely it happens. But yes, I think we all understand the threshold for Taylor and Lawrence and CPR 52.30 is incredibly high. It's a very rare case indeed that meets it. It does happen. It has happened in high-profile cases. And if it is open to the court to have repeated reconsideration decisions of its incidental decisions and procedural matters, then some consideration needs to be given, and perhaps some guidance needs to be given on what basis would you look to it. And one might look by analogy to CPR 3.17 and the Tibbles case law when a final order at first instance could be set aside. But the point in the end, and with the interesting cases about the scope of all these different rules set out in our skeleton, is there is nothing in this application which justifies a third consideration of the same position. It's effectively just the merits of the case again, and my Lord Justice Newey has considered it carefully twice, and there's no reason to say that there should be a third appeal. A third application for.
So just translating that into my own words, do I understand you just be making 2 points? Firstly, even under 2052, 24.6, there's no right to an oral hearing, come what may. But so far as the threshold question is concerned, having had 2 bites of the cherry, even if there's jurisdiction to have a third bite, they've got to show that there's something different this time around.
Yes. I think
simply say we're applying for reconsideration for a third time, and we refer you to what we said last time. That can't be enough, you say.
Yes, my lord. Can't be enough to justify the court having to go into it again and deal with the merits again until such time as a civil restraint order is made. Which would be, if you had 20 applications on the same basis, probably the end result.
But that wouldn't assist, because they would simply apply for permission under the CRO.
There must come a time, my lord, when this court says, we've looked at this again, there's nothing new, we're not looking at it.
Not that applies to the Taylor and Lawrence jurisdiction.
But the
CRO won't help, because of course you can apply time and again for permission to make the application.
It doesn't help in stopping it from crossing the desk of a single judge, I accept. It does stop you from coming before a full court on an oral hearing.
The CRO is really intended to prevent the respondent from being exposed to repeated costs unnecessarily.
Yes.
It doesn't save the judges from having to look at applications.
No, I'm afraid not. But it's, and that's by the by. I was simply saying, well, I suppose there is that other safety net, but not, as my lord says, really a safety net for the court at all. So we say, well, what is it in this? Even if there is jurisdiction, which, as I say, for the reasons in the skeleton argument, isn't clear at all, on what basis could it be exercised that the court should look at the merits of this a third time? I think that's everything I need to say on that application, my lords. Unless I can assist you further, those are my submissions.
No, don't seem to have any further questions, so thank you very much. Mr Bogle, any reply?
Yes. Just a couple of points, my lord. First of all, in answer to my Lord Justice Arnold's question, yes, of course, you've got to show something this time round is the usual position. Can't just say, I refer to what I said last time, to which the response will be the same. There is something different. There's Rajpal 3. In addition to what my Lord says, that of course under 5230 you can come back again and again and again. There's also a fallback position, and I suppose ultimately it's CPR 3.12M. That may be an old standby, but in my submission answers the jurisdiction question raised by my learned friend. In relation to the issue of mens rea, the fact that she may or may not be able to perform mens rea, according to Dr. Rajpal, isn't relevant to what your lordship has to consider. It's not what is done at the time of the acts and omissions. And for all we know, subsequent medical evidence may say, yes, possible she could have formed mens rea at that time. We're talking about at the time of trial, because we're talking about a fair trial. And at the time of a trial, mens rea isn't the right concept. What is the right concept is fitness to plead, fitness to stand trial, give evidence, give instructions, and understand what is going on. So actually that comment of Dr. Rajpal doesn't assist the court any further. My learned friend says, well, the comments of Dr. Rajpal on autistic burnout, and indeed on other matters, don't meet the medical test as fully as my learned friend suggests, i.e. myself. Well, in my submission, that simply adds to my primary submission that further medical evidence is needed. And likewise, his comment that it might not be enough to become unfit to plead, engage or instruct. Well, we need specific evidence on that particular point. A generality one way or the other isn't going to help the court. And I think that is all. That's all I had to say, my lord. I hope that's
It does. Thank you very much.
My lord, I have a surreal point of housekeeping to raise before anything further is said. I'm doing so just at the end. I've received, and Mr Bogle has received, though he may not have seen them yet, and various other people have received, a series of emails this morning from a Miss Anar Sheikh, who had a practice which was intervened in some years ago, which set out, at some length, I can see the supporting documents run to 1,200 pages, a contention that the whole business of intervening in solicitors' practices is unlawful and fraudulent, and that Ms Khan's imprisonment is therefore unlawful. I don't want to give this any more credence than I need to, but I just wanted to make this constitution of the court aware of it, because the email seems to suggest that this has been sent to the Lady Chief Justice, the Master of the Rolls, the President of the Supreme Court, and indeed the interim applications judge of the Commercial Court, as well as Mr Justice Leech.
essential inclusion.
In case this constitution is asked about it, I didn't want the court to leave without being aware that it was there. I don't propose to give you any of these documents unless the court would like to see them.
No, that's fine. Thank you very much. Thank you. Thank you both very much for your helpful submissions on what obviously is a sensitive case. As you would expect, we're not going to give judgment here and now. In advance of the judgment being handed down, in the normal way, you will be supplied with it in draft for you to correct our English and typing, but not to re-argue the points. Of course, when it does reach you, it will come with the embargo. I think you have helpfully already supplied lists of email addresses to which the draft should go. I would remind everybody of what they already know, which is the importance of complying with the embargo and the importance that the Master of the Rolls in particular attaches to that. In advance of the hand down, we'd be grateful if the parties would seek to agree an order dealing with consequential matters. If there are points on which they can't agree, we'd be grateful for brief written submissions, and we would expect to rule on the points in the order that we make. But thank you again.
My Lord, just
Yes.
I have handed up some authorities and some I haven't. Does your Lordship need copies of those? That
I'm forgetting which ones we're talking about, but insofar as
I think it was
told us you were going to supply
just
them,
invidious, I think was the only one.
I think that is it. I'm sure we can find it for ourselves, but to be on the safe side, if you could email it through, that would be helpful.
We certainly will, my Lord.
Thank you very much.
All right.
Can you send me a